Assalamualaikum and good day to Prof. Mada Dr. Alias. This is a group presentation video on the fundamentals of Hart's concept of legal system. The group members are Bhavani Munisami, Sarah Auni, Khairu Kristina, Nur Hidayati Asilah, Farisha Natzatul Azwa, and Nurul Farhana. Now, let me start with the introduction of Hart. Hart, or his full name is Herbert Lionel Adolphus Hart, was born on 1907 and died in 1992. He was an English philosopher, a professor of jurisprudence at Oxford, an author who was the foremost legal philosopher and one of the leading political philosophers of the 20th century. Hart was a leading figure in the post-war movement for the revival of interest in philosophy of law in relation to the much wider field in general philosophical inquiry. He was interested specifically in the development of the doctrine of legal positivism and elaborate his view of the fundamentals of a legal system in the concept of law. So, legal positivism is a doctrine which rejects any metaphysical speculation about law. It is also considered as a view of law which only regards to the positive law, such as law as it is and not law as it ought to be. It can be summarized with the statement, the existence of law is one thing, its merits and demerits another. For the connection between law and morality, Hart emphasized that the connection was not a necessary one. Law still can exist without morality. Law can be moral, immoral, and amoral. Legality is one thing, while morality is another. Next, Bhavani will be talking about Hart's legal system.
Thank you, Khairu Kristina. Now, let's move on to discussion of ideas, specifically the form and the content of a legal system. But first, let us discuss the primary and the secondary rules of Hart's legal system. So, here we go. So, what does it mean by legal system? So, according to Hart, legal system means union of primary rules of duty and secondary rules of recognition, change, and adjudication. So, Hart categorized the legal system into two, which is the primary rules and the secondary rules. So, primary rules are the rules of conduct that tells us what we are legally obligated to do and what consequences attach to obedience or disobedience. In other words, primary rules are the rules that impose duties which involve physical movement or changes. Let's take for example like criminal prohibitions and also individuals' right to freedom of speech. So these examples actually comprises of law subjects and there are impositions of duties. So Hart argued by requesting all his readers to imagine if we are only governed by primary rules. What will happen? This is because according to Hart, primary rules consist of some defects. What are they? The first is uncertainty to apply and distinguish these rules. Second, these rules are static as society will eventually change over time. And third, maintenance of this rule is very much inefficient. Why? Because there are absence of authoritative judge of disputes. Moving on to the secondary rules. Secondary rules means legal rules that allow for creation, extinction, and alteration of primary rules. Secondary rules are the rules that govern primary or secondary rules. Let's take for example contract law rules that enable parties to form contract and the rules that allow testators to create a will. So without secondary rules, the society will be in static and there will be no variation. So secondary rules also consist of three types, which is the first one, rules of recognition. It means it identifies the primary rules. Second, rules of change. It gives power to change the primary rules. And third, rules of adjudication. It means it gives power to adjudicate disputes and pass judgments and order. So all in all, secondary rules enables individuals to create customized primary rules that govern their relationship as well as their privately owned resources. So that's all from me about the primary and the secondary rules of hard legal system. Now I will pass this discussion to Sarah Auni. Here you go.
Thank you, Babani. We will now continue and move to the second discussion under the form and content of a legal system by Hart, which is the minimum content of natural law. Hart claims that all legal systems share what he calls the minimum content of natural law. This is justified by the fact that most men, most of the time, wish to continue in existence. Thus, without such a minimum universal content, laws and morals could not forward the minimum purpose of survival. Given a few universal facts about human nature and the world in general, such as human vulnerability to bodily attack, approximate equality in physical size and strength, and the relative scarcity of natural resources, these, Hart argues, are some features of human condition which sometimes work against survival, and believe that every legal system must take this into account. Therefore, Hart enumerates a series of such rules of conduct which, taken together, form the necessary minimum content of natural law that any moral or legal practice must contain if it is to endure. Absent of this common element will cause social life in its entirety to disappear, and not merely in its legal and moral aspect. Now you have heard about Hart's idea regarding form and content of a legal system from Babani and I. Now let's move on to Hart's analysis of distinction between law and morality. There are four features to distinguish morality from law, which are the non-deliberate character of moral change, the necessary importance of moral rules, moral and legal responsibility, and moral and legal sanctions. These four features represent the core of his attempt to enlighten the distinctive structure of a legal system. The first feature to distinguish morality from law is the non-deliberate character of moral change. Although the legal rule may be introduced or eliminated by deliberate enactment, moral rules principles, on the other hand, are not subject to deliberate change by enactment. We can imagine a community of individuals bound together by a set of rules which define their moral obligations to one another as well as to those outside of the community, which is nevertheless not itself a legal system. It is just a moral obligation. If we refine our imaginary picture by assuming that the members of this community all believe that the ethical pronouncements of one particular member are morally binding upon the others, we do not necessarily transform our imaginary community into a legal system. If so, we may very well possess the authority to make and unmake the community's morality by proclamation. Such laws are distinguished from traditional and established patterns of ethical conduct by the very deliberateness with which their guiding principles have been formulated and not subject to deliberate change by enactment. Next, I will let Hidayati to continue with the second distinction.
Now, I will talk about the necessary importance of moral rules. Hart's second ground for distinguishing morality from law rests on the proposition that importance is not essential to the status of all legal rules as it is to that of morals. By this, Hart means that while a law that is generally thought quite unimportant to maintain remains a legal rule until repealed. By contrast, it will be absurd to think of a rule as part of the morality of a society, even though no one thought it any longer important or worth maintaining. The force of this argument derives from Hart's distinction between acceptance and validity. According to Hart, all of the rules of a legal system except one, the rule of recognition, belong to that system by virtue of their legal validity. They are part of the legal system regardless of whether they are observed or enforced, because they derive from or pass all the tests contained in the rule of recognition. That rule itself is neither valid nor invalid, for while it is the creation in accordance with which the validity or invalidity of all the other rules of the legal system is determined. There is no rule providing criteria for the assessment of its own legal validity. The rule of recognition is included in the legal system, but its inclusion rests upon a different ground, upon the fact that it is simply accepted as appropriate for use. Thus, for heart, any rule other than the rule of recognition may be part of a legal system, may exist as a legal rule, despite the fact that it is not accepted, such as observed or enforced, as long as it passed the test of legal validity stipulated by the rule of recognition on itself. Hart argument that importance is a necessary feature of all moral rules amounts to the contention that the distinction between acceptance and validity has no application to moral system, such as that a rule or principle can be part of a moral system only if it is accepted as appropriate for use. This view is a mistake one. There is no absurdity in thinking that a particular moral rule belongs to a system of such rules, despite the fact that it is neither observed nor enforced. A rule may belong to a system of moral rules if it meets the criteria of validity specified by that system's rule of recognition and despite its non-acceptance in practice. Obviously, what this view depends upon is the assumption that a moral system may be complex enough to contain rules of two sorts: those which belong to the system merely because they are accepted as appropriate for use, and those which belong because they satisfy all of the tests laid out in some master rule or rule of recognition without thereby automatically becoming a legal system.
Okay, thank you Hidayati. Now let's talk about the moral and also legal responsibilities. Okay, the third basis which Hart offers for distinguishing law from morality is that to understand this, we can put simply like Hart claims that legal system may for certain types of offence impose strict liability and make responsibility independent of mens rea altogether, except for the minimum requirement that the accused person must possess a normal material code. Therefore, the strict liability in morality is unthinkable, and also like for some reason this claim is actually a plausible. Okay, when we talk about strict liability, the rules of strict liability which impose upon the liable party is a responsibility to act in a certain way. So for example, when an accident happen, person A must do something. So in this case, the person who caused the accident, which is the person A, must pay compensation towards the injured party, which is the person B. So despite the fact that the accident was in no way subject to the control of the person A, but it is of course true that A cannot excuse himself from the duty imposed by the rule on the grounds that the accident was not within his control. However, if he could, that means the liability would not be strict. But what if A seek to excuse himself on the ground that he is unable to pay or to perform the duty which the rule has imposed toward him, maybe because of he is penniless or does not even have any money? An assumption is built into the rule that A is capable of performing the duty which the rule imposed, even if he was utterly unable to prevent the accident from occur. So the rule tells A he must do something, he must pay the compensation if accident happen. So it is not a prediction that he will fact do it. This actually much follow from the Hart's own analysis of rules, and to the extent that the rules commands A to do something and that it imposes an obligation on A, and even if it presupposes that what is required of A is within his power to perform. Of course, this presupposition may not always be accord with the facts. If A is considered penniless, then he is unable to pay or to compensate B. So moreover, A's poverty will be the mitigating factors that will provoke the judicial leniency or even forgiveness. But however, it must depend on either the loss is within his own control or beyond his control. A's inability to compensate B
morality is not an excuse which merely has to be asserted in order for A to be released from his own obligation to do so. So when strict liability is disserted in this way, it becomes clear that it has some sort of moral analog. So we acquire moral obligation as a result of the happening of some event utterly that is beyond our control. So therefore, we can see that a citizen of a particular state may have some positive moral obligation to help eradicate an institution in which existed before she or he was born, or in which he or she had no part in making it. Both law and also morality, obligation can be conditioned on events beyond the control of individuals or our own control. So on whom the obligation is imposed to. So, and even in both law and also morality, the imposition of any obligation necessarily presuppose that the obligation can be satisfied, although in both law and also morality, this presupposition may be overridden in particular cases. So while the event which triggers someone's or individual's moral or also legal obligation, it can be defined as being beyond our control or beyond one's control. So the action which the obligation prescribe or prohibits cannot be. So actually this fact are far from marking a distinction between law and also morality, which this point to one of their deepest affinities. Furthermore, there is one situation in which Hart's distinction makes sense. So let's imagine although A has broken the rule of law, but there is no sense that in which he can be said as violated under a rule of morality. He is tried and also convicted of the crime of possession, and also he is sentenced to a term in prison. So although in this situation A is considered broken a rule of law, but we can see there is no way or there is no sense in which he can be said to have violated a rule of morality. So it is true that A has broken the law. The rule which he has broken, however, did not require him to do or to refrain from doing anything. So the rule does not include an ought directed to A at all. So the rule merely says that something will be done to A upon the happening of an event which might well be beyond A's control in this case. So A will be punished or sanctioned for the possession of dangerous drug despite his own ignorance regarding the fact of the possession. However, in this case, this distinction does not turn upon some differences between the legal and also moral responsibility. Or if one wants to insist that it does, the concept of responsibility must be redefined in terms of the concept of sanction. Therefore, I'll pass to Farisha as she will explain more about the legal and also moral sanction. I'll pass to you, Shah.
Thank you, Fana. So now I'll be presenting about hard, moral and legal sanction. Before we get to the topic, let me explain a bit what is the meaning of the term sanction is. Basically, the term sanction is derived from the Roman law, and the term sanction means a mere penalty that purposely bring a better performance and executions of law. Sanction and punishment are always considered the same. However, these two terms have different meaning. Sanction consists of the application of the physical force of the state for the enforcement of the law, while punishment is an act inflicted upon a wrongdoer. When it comes to morality, Hart also disputes the central perception of natural law. For Hart, legality is never determined by the morality, but it's determined by the social practice. The way he sees it, if judge must resort to morality to issue a ruling, then the content of law become arbitrary, as we require more than social fact to figure it out. Think of this way: if morality is the basis of law, so whose morality is the judge to apply when resulting in a conflict? Is it the lawyer? Is it the government? Or is it the involved parties? Unlike law, it's contained in a statute or judgment, while morality is difficult to pinpoint. A citizen must be capable to distinguishing between the demand of their conscience and the demand of the state. However, he does not deny the existence of morality as the influencing methods in law. Hard understanding between law, morality, and coercion does appear more nuanced. According to Hart, To understand this, Hart believed that legal rules are primarily enforced through the threat and actual use of physical sanction, while by contrast, the typical form of moral pressure consists in appeal to respect for the rules as things which are important in themselves and presumed to be shared by those addressed parties. This means the enforcement of moral also plays an important role in the enforcement of rules of a legal system. The moral system may prescribe physical punishment for those who break the rules, so as long as the imposition of such punishment effectively prohibited by the official authorities for enforcing independent systems of rules, it will still remain in the moral system. It's just at some point where this disability is overcome that it is no longer correct to speak of the rules in question as moral rules, for to extend in the situation such rules are effectively enforced by physical sanction as law. According to Hart, if law differs from morality concerning the type of sanction which it employs, then it's also differ concerning the mode of its administration. Typically, moral sanctions take the form of general diffuse hostile or critical reaction. By contrast, legal sanctions are typically administered by centralized official organs that possesses the exclusive authority to punish violations of the law. Hence, when an individual breaches a moral duty, any other member of the moral community to which he belongs may impose appropriate sanction. However, when a rule of law is broken, not every member of the legal community is equally qualified to inflict an appropriate punishment to the wrongdoer. The right and the ability is to impose legal sanction rests exclusively on the official authority who are alone empowered to act in the name of the legal system. With that, I will pass to Christina.
Thank you, Farisha. So, based on the previous discussions, it is clear that Hart's legal system can be categorized into two parts, which are the form and content of a legal system and his analysis of the distinction between law and morality. In the first part, there are two rules that are vital in a legal system, which are primary rules and secondary rules. Both rules have their distinction. However, they both are necessary as to govern the society. In addition, Hart claims that all legal systems share what he calls the minimum content of natural law. He insists that when absent of the common element of natural law, then it will cause social life in its entirety to disappear. For the second part, Hart gives 4 arguments in distinguishing morality from law, which are the non-deliberate character of moral change, the necessary importance of moral rules, moral and legal responsibility, and lastly, moral and legal sanctions. In conclusion, Hart's concept of a legal system can be referred as a union of primary and secondary rules embodying a minimum content of natural law and enforced by a determinate class of officials possessing an effective monopoly over the available physical sanctions within a delimited territory of conduct. That's all from us. Thank you.